Level 1, $0. You are charged with possession, not dealing, not trafficking, possession. 31 grams found in your jacket pocket during a stop that lasted 11 minutes on a Tuesday evening, 3 blocks from your apartment. You do not have a lawyer. You cannot afford a lawyer. The court appoints one. His name is on a list of public defenders who rotate through this courthouse on Tuesdays and Thursdays. He has 138 active cases this month. Yours is number 139. You meet him for the first time 9 minutes before your arraignment. He is reading your file while you are being introduced. He asks your name. He asks what happened. He listens for 4 minutes and then tells you the prosecutor is offering a plea. 18 months probation, mandatory drug counseling, a fine of $800. You ask if you should take it. He says it is your decision. You ask what happens if you don't. He says the trial date would be set for approximately 5 months from now, and the charge carries up to 2 years. You ask if you would win at trial. He pauses. He says it depends. You take the plea. You do not fully understand what you agreed to until 3 weeks later when you miss a probation check-in because your shift ran late, and nobody told you that missing a check-in is a violation that sends you back in front of a judge. The judge does not remember you. You are a case number to him. Your public defender is not in the room. A different public defender is standing where he stood. She has never seen your file. She reads from it quickly while the judge waits. You receive 30 days for missing a meeting, for a charge that began with 31 grams in a jacket pocket. The system did not fail you. The system processed you exactly as designed. Level 2, $5,000. You scraped together $5,000. Your mother lent you $2,000. Your cousin lent you $1,500. You sold the PlayStation and everything attached to it. You borrowed the rest from a man at work who said, "Take your time," but you both know that means something specific. $5,000 gets you a private attorney. Not a good one. Not yet, but a private one. His office is on the 4th floor of a building that has seen better decades. The carpet is the color of a decision made in 1991. And never revisited. He has a paralegal named Sandra who answers the phone and knows your file better than he does, but he shows up. That is the difference between $5,000 and 0. He shows up to every hearing. He files motions, not many. He does not have time for many at this rate, but he files a motion to suppress the evidence from the stop on the grounds that the officer lacked reasonable suspicion. The motion is denied, but it was filed. At $0, nobody filed anything. He negotiates with the prosecutor, not as equals. The prosecutor knows he is working a volume practice at this rate, but he negotiates. The 18 months probation becomes 12. The fine stays. The mandatory counseling becomes optional after 6 months of clean check-ins. You take the deal. You leave the courthouse with a lighter sentence than the man who stood in the same spot last Tuesday with $0 and no one who showed up. Same charge, same facts, same courthouse, different outcome. The difference was $5,000 and a man who showed up. Level 3, $25,000. $25,000 changes the conversation. Not the law, the conversation. Your attorney has a real office now, clean carpet, a receptionist who is not also the paralegal, a conference room where you sit across a real table and he closes the door and speaks to you like a person making decisions rather than a person being processed. He has reviewed the stop in detail. He has a private investigator he uses for cases like this. The investigator pulled the officer's body camera footage and cross-referenced it with his incident report. There is a 17-second gap between the stated reason for the stop and the actual interaction captured on camera, 17 seconds. Your previous attorney would not have found this. He would not have had time to find this. Your attorney files a second motion to suppress. This one is different. This one has exhibits. This one has case law from 3 jurisdictions. This one arrives on the prosecutor's desk, 48 pages long, and the prosecutor reads it over the weekend and calls your attorney Monday morning. Not to fight it, to talk. The charge is reduced, not the sentence. The charge. From possession with intent, which carries a felony record that follows you to every job application, every apartment application, every background check for the rest of your life. A misdemeanor. You complete a diversion program, 6 months, clean record at the end. The man at $0 is 30 days into a sentence for missing a probation check-in. You are 6 months from a clean record, same city, same courthouse, same Tuesday evening stop. $25,000 is the distance between those two outcomes. Level 4, $150,000. At $150,000, the system stops being something that happens to you. It becomes something you navigate. Your attorney is a name in this courthouse. The prosecutors know him. The judges have seen his work. When he files a motion, it is read carefully, not processed automatically. He brings in an expert witness, a forensic chemist who has testified in 47 cases and whose credentials occupy 2 pages of your pretrial motion. She disputes the lab analysis of what was found in your pocket. She raises questions about chain of custody, about testing methodology, about the specific compound identified, and whether the test used was calibrated correctly on the date it was administered. The prosecutor's case was simple 48 hours ago. It is not simple anymore. Your attorney also hires a jury consultant, a woman who has spent 20 years studying how jurors make decisions, what they notice, what they dismiss, what body language reads as credible, and what reads as rehearsed. You spend 3 hours with her before the trial. She tells you how to sit, how to respond when something is said that upsets you, what to wear on which day, how to make eye contact with the jury in a way that feels human rather than calculated. She is teaching you to be perceived correctly. The man at $0 was perceived as a case number. You are being prepared to be perceived as a person. The jury deliberates for 4 hours. Not guilty. You walk out of the courthouse on a Wednesday afternoon into ordinary sunlight. Somewhere in the same city, a man who could not afford the forensic chemist, or the jury consultant, or the attorney, whose name the prosecutors know, is finishing month 2 of a sentence that began with the same 31 grams. Same evidence, different resources, different verdict. Level 5, $500,000. At $500,000, you do not go to trial, because at $500,000, your attorney makes sure you never get to trial. He has been in this city for 26 years. He knows the prosecutors by their first names and their career ambitions. He knows which ones are building toward political office and which ones are building toward a partnership at a private firm. He knows what each of them needs from a case and what each of them would accept to make it go away cleanly. This is not corruption. This is information. And information at this level is worth more than any motion or any expert witness or any jury consultant. He meets the lead prosecutor for coffee, not in the courthouse, not in an office. Coffee. The meeting lasts 40 minutes. You are not there. You find out the outcome in a phone call 2 days later. The case is declined, not dismissed, declined. The prosecutor's office has determined that the circumstances of the stop do not meet the threshold for prosecution, given the resources required and the evidentiary challenges identified. This language means something specific. It means the case costs too much to win against your attorney, and the return is not worth the investment. You are not innocent, and you are not guilty. You are not worth the fight. The man at $0 was worth the fight, because the fight cost nothing. You cost too much. The case does not exist anymore. Level 6, $5 million. $5 million does not buy you justice. It buys you a different system entirely. Your legal team is 4 people, a lead attorney who has argued before the Supreme Court twice and whose hourly rate is $950, a second chair who handles research and motions, a private investigator who is a former federal prosecutor, and a crisis communications consultant whose job is not your legal case but your public case, the story that exists outside the courtroom, in the newspapers, in the financial press, in the conversations that happen between people who matter. Because at $5 million, the charge is not possession. At $5 million, the charge is fraud, wire fraud, securities fraud, the kind of charge that arrives not with a Tuesday evening stop, but with a morning knock and a sealed indictment and your name in the financial press by noon. Your attorney files 41 motions before the trial date is set, not to win 41 motions to exhaust the prosecutor's office. Federal prosecutors have budgets, they have caseloads, they have supervisors who review resource allocation quarterly. When a defense team files 41 motions across 18 months, someone in the Department of Justice is doing math about whether this case is worth what it is costing. Your communications consultant is managing a parallel story, not your innocence, your complexity. Every article that runs about your case includes a quote from a former colleague about your philanthropy. Every profile mentions the jobs your company created. The story being told in the press is not guilty or not guilty. The story being told is, this is complicated and the government may be overreaching. That story reaches jurors before the trial begins, because jurors read the news. 14 months after the indictment, the Department of Justice offers a settlement. No prison time. A fine of $2.3 million and a deferred prosecution agreement that expires in 3 years if no further violations occur. $2.3 million on a $5 million legal budget. You spent $5 million to pay $2.3 million. You are not in prison. You are at a dinner in a restaurant that has a waiting list. Level 7, $25 million. At $25 million, the law does not change. The people enforcing it do. Your attorney is not someone you found. He is someone who was recommended to you by 3 other people at your level who had already needed him. His client list is not public. His case outcomes are not discussed in press releases. He operates in a register of legal practice that most people do not know exists because most people never need it. He has relationships, not with prosecutors, with the people prosecutors report to, not with judges, with the people who appointed judges, not with regulators, with the former regulators who now sit on the boards of the institutions being regulated. These relationships are not corrupt. They are structural. They are the natural result of decades of movement between the highest levels of law, finance, and government, and they exist completely legally and completely invisibly to anyone operating below a certain altitude. Your case is resolved before it becomes a case. An inquiry from a regulatory body arrives. Your attorney calls a former colleague who now sits at the senior level of that regulatory body, not to interfere, to understand the scope and timeline. The inquiry moves in a direction that allows for a voluntary disclosure. Your company self-reports a compliance failure, you cooperate fully, you accept a consent decree, no admission of wrongdoing, a fine that represents less than 1% of the revenue generated during the period under review. A monitor installed for 18 months to review your compliance program. The monitor is a law firm whose senior partner had lunch with your attorney 6 weeks ago. You are not prosecuted. You are monitored by people who know the people who know you. The man at $0 is in month 11 of a sentence for 31 grams. You are in month 2 of a monitored compliance program for a financial irregularity that generated 9 figures in revenue. Same country, same legal system, different altitude. Level 8, $50 million. At $50 million, the system is not something you navigate, it is something you have helped build. Your name appears on the donor walls of 3 law schools. One of them named a building after you 7 years ago. The judges who sit on the federal bench in 2 jurisdictions were clerks who were trained in institutions your philanthropy funded. The regulatory frameworks that govern your industry were shaped in part by working groups that your attorneys participated in and your lobbyists influenced. This is not conspiracy. This is how systems accumulate the preferences of the people who fund them over decades. When the inquiry comes, and at $50 million an inquiry always comes, not to you, to your general counsel, from a former colleague who is now at the agency conducting the inquiry. The phone call is a courtesy. It is not legal, it is not formal, it is a professional courtesy extended between 2 people who have known each other for 20 years and who understand what the call means without saying what the call means. Your general counsel calls your outside attorney. Your outside attorney calls 4 people. By the time the inquiry formally arrives in writing, your team has already been preparing for 6 weeks. The response is 112 pages. It reframes the question the inquiry was asking. It does not answer whether the conduct was improper. It argues that the definition of improper being applied does not accurately reflect the regulatory intent of the statute as understood by the people who wrote it, several of whom your attorney can name because several of whom he knows personally. The inquiry is closed, not resolved, closed, for insufficient evidence. In the 3 years that follow, you speak at a symposium on regulatory reform, you sit on an advisory board for financial market oversight, you give a keynote at a conference where 3 members of the relevant regulatory body are in the audience. After the keynote, a regulator approaches you. She says she found your remarks on compliance culture very thoughtful. You thank her, you have a drink. You do not discuss the closed inquiry. You do not need to. Somewhere in this country right now, someone is sitting in a room waiting for a public defender who has 139 cases this month. They are charged with 31 grams. They have not been told yet what they are agreeing to. They will take a plea. They will miss a check-in. They will receive 30 days for the missing. They will serve the 30 days. They will return to a world that now sees them differently because of what happened in a room where they had 9 minutes and a man who was still reading their file. And somewhere else in this country, a man who built $50 million is being thanked for his thoughtfulness on compliance culture. Same country, same laws, same courts, different wallets. The court doesn't change at every level. The court reveals what it always was.